Be seated. All right, Michelle, it looks like we are recording and streaming. Can you confirm before we begin? Okay. All right, good morning, everyone. I am convening the hearing on the unanimous settlement agreement in the matter of the application of Evergy Kansas Central, Inc. for a siting permit for the construction of a 345 kV transmission line in Reno County, Kansas. For those of you participating online, please bear with us if you experience any technical glitches. We will begin with entries of appearance, and I will start with Evergy and Mr. Cole Bailey.
Hey, good morning. Cole Bailey and Kathy Dingus for Evergy.
All right, good morning. And for KCC staff.
Patrick Hurley appears on behalf of KC staff and the public generally.
Okay. Does staff have a recommendation regarding notice of this proceeding?
We do, Mr. Chairman. On February 19th, the parties to this docket filed a joint motion to approve unanimous settlement agreement and requested the commission convert the scheduled evidentiary hearing to a one-day settlement hearing for March 9th, 2026. On March 3rd, the commission issued an order converting the evidentiary hearing to a one-day hearing on the unanimous settlement agreement for you today. The one-day settlement hearing was set for Monday, March 9th at 10 a.m. in the first floor hearing room at the commission's offices in Topeka. The order was served on all the parties in the docket, noting the date and time of the settlement hearing. Accordingly, staff has examined the notice and asked the commission to find the notice in this matter as proper, and that the commission has authority to convene this public hearing at this time, date, and place.
Any objections? Hearing none, and based on staff's recommendation, I will find that notice is proper. The commission has jurisdiction over this proceeding at this time and place. And while we're on the topics of entries of appearance, I just want to note for people that Commissioner Keene is with us this morning, but he is online virtually, and you can see the other two of us are here in front of you. So there he is in the sunflower field. All right, now let's move to preliminary matters. I understand the parties are going to move or would like to move to admit all the pre-filed testimony into the record. Is that staff or Evergy?
I can handling
that. Please proceed.
Staff moves the commission and requests that the pre-filed direct testimony, answering testimony, rebuttal testimony, public comments, and testimony in support of the unanimous settlement, and all the exhibits filed by the parties in this docket be admitted into the record into this matter.
Any objection? Hearing none, the motion will be granted. All the referenced testimony and exhibits are admitted. Moving to the procedure for the hearing, I understand at the pre-hearing conference, the parties agreed Evergy would like to make an opening statement and request 5 to 10 minutes, and then commission staff requested about 3 to 5 minutes. After those opening statements, we'll follow the order of witnesses agreed to in the pre-hearing conference. And I also understand that the parties indicated they do not anticipate making closing statements. So we will move to opening statements, and we will start with Evergy. Mr. Bailey.
Good morning, commissioners. Thanks, Michelle. My name is Cole Bailey. I'm going to briefly go over the application and the unanimous settlement agreement between staff and Evergy. The application was filed as a result of the 25207 predetermination docket. That's where the commission predetermined the rate-making treatment for the McNew gas facility in Reno County, Kansas. So essentially, Evergy, we needed to connect the new plant to the rest of the transmission grid. After the 25207 docket, we held open houses in summer of 2025. And then we performed a routing study after that. From the information we gathered from the open houses, we analyzed over 1,000 different routes, and then we came up with the preferred route and filed the application. As you know, there's no other interveners in the docket. It's just staff. Staff filed their direct testimony. They made one route modification, and then staff witness Leo Haynes made requests or recommendations in our protocols. And we accepted all of the one modification and then the protocol recommendations, except for one, which was not applicable to Evergy. That was the one about changing language in a restoration agreement. Evergy doesn't have those. So we were in full agreement at settlement here at the settlement conference. We made one more modification. This came as a result from a landowner request. He requested that we move the route just about 300 feet west on his property. So he had 2 tree lines. We went just west of his tree line. So we had to cut trees further away from him, but still leaves a barrier around his house. And this is the final route on screen right now. If you have any questions about specifics, Scott Lord will be up shortly to answer. But that's the final route, and that includes the modifications. And then we also filed our protocols, the edited protocols on Friday. If you have any questions, I can answer those questions, or we have with Scott here for those. Evergy believes the settlement is based on substantial competent evidence. It's in the public interest and it's just and reasonable. As I mentioned before, we analyzed over 1,000 routes, and we selected a route that staff and Evergy believe is least impactful to landowners. Public interest is served by approving this unanimous settlement agreement to allow the new McNew plant to connect to Evergy's transmission system and serve customers, strengthen the capacity and reliability of its system, and meet and supply the needs of growing demand. And I'll stand for any questions. Thank you.
Thank you. I don't believe we have any questions, so we'll move
Chair
to.
French, if I can interrupt, I'm sorry that the cameras are fixed on the commissioners, and so anybody from the public couldn't see the route on the screen, or they can't see the speakers at the podium.
Oh, okay.
Sorry for the interruption.
Yeah, Michelle just may want to change it so that it can spotlight on the podium when folks are speaking. Okay, I think we're good. Staff, your opening.
Thank you, Chairman French and Commissioners. Good morning. The staff supports the statement made by Evergy in their opening statement, and will expand on why staff supports the unanimous settlement agreement. Staff witness Paul Owens has filed and will also testify that the unanimous.
Make sure you've got your microphone. Yeah. There you go.
Settlement agreement meets the standards used to review unanimous settlement agreements under Kansas law, and is supported by substantial competent evidence, is just and reasonable, and is in the public interest. The settlement agreement is supported by substantial competent evidence in the record. As Evergy just mentioned, on November 6th, they filed a docket in 25-207 for 2 new gas plants, and those gas plants were approved. One of those gas plants was called McNew, set in Reno County, and the commission found that the power plant was reasonable, reliable, and efficient. Therefore, the McNew power plant is a necessary facility for Evergy to maintain reliable electrical service in Kansas. And this particular line that we're here to go over today connects that power plant to the power grid. In essence, if you don't have the line connecting the power plant to the grid, you can't really use it. And so it's necessary. Ultimately, the Evergy filed a transmission rights only certificate in docket 26089. In that particular application, they identified the specific location of the line at issue here today. That was conditionally approved by the commission. As I mentioned, the McNew line between the power plant and the substation is a critical component for that facility. The evidence shows that the transmission line route is reasonable. The commission issued an order on January 23rd, 2005, adopting the document titled Guidance to Kansas Electric Transmission Line Siting Principles and Priorities. The line siting guidance document required the submission of a routing study, agricultural impact mitigation, landowner, and oil and gas industry protocols. Evergy submitted a routing study and the protocols in response to this docket. The submission of these requisite documents supports the reasonableness of the McNew line. The Evergy's routing study considered a reasonably large study area. The routing study evaluated numerous line segments. The size of the study area and the number of segments allowed staff to consider multiple alternative routes. The routing study used a methodology similar to that of other routing studies completed over the past 25 years. The routing study utilized principles and weighted criteria consistent with line sighting guidance document to assess the impact of each route. Evergy incorporated landowner comments into its routing study. The routing study supports the reasonableness of the transmission line's route. Staff identified one modification, as Evergy just mentioned, in the preferred route to decrease residential proximity and address public comments. Evergy agreed to the modification to reduce the impact on the affected parties, and that demonstrates the route's reasonableness. The settlement agreement is in the public interest. The McNew line provides direct benefits to Kansas customers in the form of added reliability. The McNew power plant provides local economic benefits through job creation. The McNew line provides economic benefits throughout Kansas by increasing capacity to support load growth. The McNew line benefits customers outside of Kansas by increasing the quantity of dispatchable power available on the bulk electric system, thereby improving its reliability. The settlement agreement includes conditions that best protect the interests of the parties and the public. Staff believes the settlement agreement is in the public interest. The settlement agreement represents a reasonable resolution of the issues in this docket, and transmission line's route is reasonable, is supported by substantial competent evidence in the record, and is in the public interest. Staff recommends the commission approve the settlement agreement. Thank you for your time and consideration. Any questions?
Thank you, Mr. Hurley. All right, we will now move on to the examination of witnesses, and Evergy, you may call your first and only witness.
Thank you. I'll call Scott Lord. Yep. Yes.
And we'll have you, before you begin, we'll have you raise your right hand and be sworn by our court reporter.
Do you solemnly swear the testimony that you will give today in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Is that on?
I think so. Yeah.
Good morning, Scott. Can you please state your name for the record?
Scott Lorg,
And who is your employer and what is your position?
Evergy, and I am a project manager in our transmission and substation construction group.
And are you the same Scott Lord who filed direct testimony on November 14th, rebuttal on February 6th, and then settlement testimony on February 25th?
I am.
And if I were going to ask you those same questions today, would your answers be the same?
They would.
No further questions. I tender for commission questions.
All right, yeah, staff has waived, so we're gonna move directly to commissioner questions. I think I'll begin with Commissioner Keen. Do you have any questions online, Commissioner Keen?
Good morning, Sheriff French. Let me ask you this just as a procedural matter. The camera shows Mr. Long from a distance of about 300 yards. Is there any way that, again, the camera angle, we're getting closer, except that's the floor.
I think the robots are working on it.
Okay,
Is that better?
that's perfect.
Thank you, Michelle.
What I'm going to say that follows here is going to be somewhat dramatic, the fact that I just asked for that. Good morning, Mr. Long.
Good morning.
Can you hear me?
I can.
Okay. All right. I have no questions for you at this time. I thought that your pre-filed testimony was really self-explanatory. So at this time, no questions from me. Thank you.
Thank you.
Commissioner Keither, any questions?
I don't really have a question, but I want to address something that was brought up in the public meeting as well as in the testimony submitted by interveners. It's the concern that the public was not well noted on this issue. And we're very unhappy about finding out after the fact that this was actually going to happen. So I don't know what you have to say about that, but I do think that we need to do a better job. Transmission sighting is difficult, as you well know, at its best. So I think we need to do a much better job of making sure everybody knows that it's coming. Thank you.
Response on the notice question?
if you're recalling to maybe some of the public comments on that they didn't know about it, there was some confusion on the GIS data. If that's what you're referring to, is a couple of people said that they didn't know about it. One of those, I will say, did get notice, and we actually had an email from him on, I think, August 4th. I'd have to refer to that date, but he said he didn't know about it till the application was filed, and we actually had an email from August of 25. And then the other one, I think it was the Reno County database was not updated, and so we did have the wrong address or wrong name on that one. But understand your concern.
Well, I appreciate that because, as we well know, it's not an easy issue to deal with. So I appreciate that. Thank you.
Good morning, Mr. Lorg. Well, I'm going to be quick also, but I do have a question. It's going to be a bit open-ended, and it also relates to some of the comments we heard at the public hearing. I thought this public hearing was interesting because you had a number of landowners that I think you all had just finished building another transmission line, a lower voltage transmission line across several of the parcels. And so some of the landowners came prepared to speak about their experience with that prior transmission line. And, some of the concerns were messes made during construction, old materials left on site, people outside of the easement. I think there may have been discussion about remediation efforts, unfortunately spreading non-native plants. So a lot of that, construction and post-construction activity and concerns. That's a concern for this line, but we all know you have another transmission line coming up, maybe even in a more ecologically sensitive area. I'm getting around to a question here. I thought your representatives at the public hearing answered those questions well. You were very forthright that for some of the easement issues, people do need to stay within the easements. For some of the cleanup issues, no, that absolutely should not be happening. But there is a recognition that some of that is happening. Have you put any new controls in place or anything that we could rely on to understand that maybe there is going to be more emphasis on holding contractors to better practices for future transmission build-outs, as opposed to kind of what we heard about with some landowners' experiences in the last couple of years?
I don't know if we've done anything different per se, but I think it brought light to the attention of detail that needs to happen. I don't know if I can speak on any new procedures other than our landowner, the protocols that we've submitted, but we have not had anything to say we will do this per se. Obviously, it brought to light the attention to detail that's needed on these projects to hold our contractors accountable.
Is there anything that the company would find helpful or think you might need as guidance if the commission wanted to make sure that that happened?
I mean, I think we'll, obviously work with whatever guidance you guys have. If there's something that you guys see fit for us to do, but yeah, I mean, like I said, the protocols is kind of where we have landed on is how we operate and do business.
Okay, very good. All right, if there are no follow-up questions from Commissioner Keene or Commissioner Keither, I see Commissioner Keene still on mute. Oh, you are waving your hand. Is that a?
Yes, please, if I could.
Go ahead.
Take a chair, French. Can you hear?
Yes, we hear you.
Okay. Just to follow on, pardon me, Mr. Lorg, I share the concern. I share the concern that Commissioner Keeter addressed as well as the chair. And so I'm going to ask you really more specifically. I mean, it's one thing to say we've got a protocol in place. It's one thing. It's another thing to try to enforce or administer that protocol. So my question to you is really quite straightforward. What steps does the company take to enforce and administer these protocols, including follow-on steps that are they're either standard operating procedures or should be?
So I think we would rely heavily on our construction supervisor. He's boots on the ground to oversee that construction. And so it is just going to be, more diligent observance of boots on the ground, making sure we're holding these contractors accountable. The statement about getting outside of right of way, I know we've done in areas where we do flag, put stakes in the ground on the edges of the right of way and put rope up, and try to say, hey, here is your boundary. So we have done that. I've seen that been done for that instance. The cleanup and mess, we just have to do better if that's the case. And I don't think that's an every project deal. Obviously, we had some issues and we've had several conversations, as what I've been told, with that landowner that had the bolts and nuts. We're not perfect, but all we can do is try to really keep the boots on the ground and make sure everything's getting done the right way.
Follow up to that yet. How do you process internally landowner complaints or concerns?
So I believe that those all get handled through our real estate department. And then we've got, obviously an agent on the ground, handling all those, and then those get back to the project manager if need be. But I believe the real estate department has their own log of landowner concerns, complaints.
Okay. I appreciate your responses. I share another concern that the chair expressed. This is a relatively short route. We have about a 15-mile length for this route. Isn't that correct?
Yes.
We have a much larger route on the docket that's going to be a follow-on docket here that we'll take up for the rest of this week in the Buffalo Flats docket. So I share the concern the chair had, because there is a lot of good faith that's being reposed in Evergy, if it is the one doing the oversight and providing for the construction, that the protocols be adhered to, that the land actually be restored and be actually treated with respect. So I appreciate your attention to these details, and I'm hopeful that improvements can be made in the future.
Understood.
Thank you. Thank you.
All right. Thank you, Commissioner Keen. Commissioner Keither, anything further for this witness? Nothing further from me. So, Mr. Lord, we thank you for your testimony today. I should ask, any redirect necessary?
No, thank you, Commissioner.
Well, then, at this time, you are dismissed and you may step down.
Thank you.
Thank you. All right, staff, you may call your witness.
Thank you, Mr. Chairman. Staff calls Paul Owens to the stand.
And we'll swear you in as well.
Do you solemnly swear the testimony that you will give today in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Owens. Can you please state your name, title, and address for the record?
My name is Paul Owings. I'm the chief engineer in the Utilities Division. My address is 1500 Southwest Arrowhead Road, Topeka, Kansas 66604.
Thank you. And are you the same Paul Owens who filed direct testimony on January 29th, 2026, and testimony in support of the settlement agreement on February 25th, 2006?
I am.
And do you have any corrections or changes to make to either testimony at this time?
Yes, I have two. My first one is, within my direct testimony, I asserted that Evergy did not use the routing criteria for length along existing transmission lines. Upon further review, I understand that the criterion was utilized in Evergy's routing study. And the second is, within my direct testimony on page 3 and my support in my testimony in support of the agreement on page 6, I referenced the location of the McNew line. I referenced a quote from an application, and when I referenced that quote, I referenced the 25207 docket, when in fact I should have referenced the 2689 docket.
Thank you, Mr. Owens. If I were to ask you the same, if you were to be asked the same questions that you've identified in your 2 sets of written testimony that have been filed in this docket, aside from the 2 corrections you just identified, would your answers be the same?
Yes.
Given that the pre-filed testimony has already been entered the record, I tender the witness for examination.
All right, thank you. Well, again, we will move directly to commissioner questions, and I will I'll have Commissioner Keen start us off again if you have any questions for Mr. Owings.
Thank you, Chair French. Good morning, Paul.
Good morning.
Well, as was the case with Mr. Lord, I found your pre-filed testimony to be very inclusive, very detailed, and as a result, I really don't have any follow-on questions at this time. Thank you.
Commissioner Keither, any questions?
Ditto to Commissioner Keen.
Well, I think I'll just ask you, Paul, some of along the same theme as the prior witness. As you can tell, a theme for me is, construction activities, appropriate construction activities, treating landowners fairly during that process, and also making sure the site is properly remediated in the best way possible, and landowners are left with, even if they're left with a transmission line, they are otherwise left with as minimal disruption as possible. And you heard everything we've heard as far as those concerns, and then I think it'll probably be a concern for a future transmission line as well. Is it your view that the landowner protocols that Evergy has submitted, are those a sufficient tool to address these issues? Would we be relying on landowner complaints to the KCC to enforce those? Is there something more the commission can or should do if that's a major issue for us, if we are concerned that construction and remediation are not ideal at this time?
Sure. Thanks, Chair French. So there are the landowner protocols, and I've reviewed those, and they adequately address the issue. And there's also a statute, I forget the number, but it requires them to restore it to pre-existing conditions. So when I addressed those comments within these dockets, I didn't think a condition was necessary for restoration since they have an obligation to restore anyhow. But I think if we could do one thing, it would be making the property owners more aware of processes at the KCC, because I feel like we've gotten good results. I processed a complaint docket in 2024 to 2025, and I believe the commission found that in part Evergy hadn't restored the property, and it resolved in an agreement between the property owner and Evergy. I think it was the Van Petten complaint, and then the specific person who spoke, the pharmacist at that public hearing, I've been in contact with him, and we have worked with Evergy on his concerns. I haven't heard from him. He seemed okay with the way things were going, and he had a new settlement agreement with Evergy. So I think in speaking with him, he wasn't aware of the processes at the KCC, and he, felt like his only recourse was perhaps district court, and there's expense with that. So I think we get good results when these property owners contact KCC staff, and we work with Evergy's regulatory, and if it escalates, they can always file an informal complaint, and we can write a report on whether they've met those obligations, and then the commission could then issue an order based on those facts?
I'm brainstorming, and that's always dangerous in this setting. And I wish I would have asked Evergy's witness this as well, but has staff thought at all about the proper channels to make our complaint processes, or even if it's our informal complaint process, working toward resolutions? Has staff thought at all about the proper channels to make people more aware? I mean, that could obviously be in a media release about any citing decisions. It could be a new notice that's required to be sent to only the landowners where construction will occur. I'm having trouble coming up with other alternatives, but has staff thought of any options that new things that we aren't doing now that might be more helpful to get the word out to those specific landowners that are going to be impacted?
I think a specific, I wouldn't say I've thought of it in the past, but since we're brainstorming here, a specific notice to that effect would be most effective. Because if we put it in the protocols and you have a bunch of multi-page documents, I think it could get lost. A media release would also, I think, be effective to, just be informative and let these people know that they can contact us and discuss disagreements, and we can work with them for a resolution.
Very good. That's helpful. I know that's not the kind of question you want to come up with a quick answer to, so I appreciate you attempting it. I don't believe I have anything else for you, Mr. Owings. Did anything I say prompt any further discussion? I see Commissioner Keene has his hand up.
Yes, thank you, Chair French. Indeed, it did. And I'm going to tag on to the concern and the questioning by the chair, and I'm going to ask this maybe a little more specifically, because it strikes me that this thing can be handled pretty directly. So my question to you is, Paul, if we add a protocol compliance verification as a condition of the citing order, wouldn't this provide a built-in follow-through and better accountability in terms of these sorts of issues that we're discussing?
So the compliance verification would be a compliance filing that Evergy would submit, to that effect. I guess I want to make sure I'm understanding, or a notice to the property owner.
No, it would be back to the commission. It would be a verification that the company has in its administration of these protocols. They have provided oversight, and they are verifying the fact that the protocols have been complied with in all of their aspects during the construction phase, and that would be as I say, that would be a condition for that they provide that verification would be a condition to the order.
I would think that would reinforce. Yes, I would think that would reinforce the protocols for Evergy to provide a verification.
If you follow what I'm saying here, and I don't hear from you, I don't hear my voice. I'm looking for something that is kind of an autopilot built-in method by which we can have assurances provided to us that protocol compliance has become a priority and has been actually executed. And I think it's a form of accountability that doesn't seem to me to be terribly onerous in terms of compliance, because we want to basically have the company verify that they have not only accepted the purview of the protocols, but they have administered and enforced them in accordance with their meaning. Your thoughts?
I understand, I think now, and I think, that additional step could occur after they've constructed it, and, they could report that to the best of their knowledge, they've complied with the protocols and completed the restoration in accordance with the protocols, and file that with the commission. That would be beneficial. And
so one more follow-on question, and I'm finished. should that not be, if you believe that that would be beneficial with respect to the current docket, why would that not be beneficial with respect to all succeeding line citing dockets that the commission considers? Shouldn't it be in the ordinary course a method of providing for accountability and follow through?
I think if we're going to require that as a condition to this docket, it would be logical to make it status quo and required for Evergy or other utilities proposing to construct transmission lines in the state.
It's a great point. It should be inclusive. I agree. Thank you. I appreciate your responses and your indulgence in my questions, Paul.
All right. Thank you, Commissioner Keen. Commissioner Keither, any further questions? I don't believe I have anything else. Any redirect from staff?
None, Your Honor. Thank you.
All right. Mr. Owings, we thank you for your testimony today. I believe you're finished and you may step down.
Thank you.
All right. I don't think we can stretch this out much longer. It's my understanding the parties have, so we've completed with all of our witness examination. It's my understanding the parties have waived any closing statements. So this does conclude our hearing in docket number 26 EKCE 0149 STG. Just want to confirm there are no final concluding matters the parties need to address. Hearing none. I will note that a commission order in this docket is due by May 13th. However, we will work to issue an order as soon as reasonably possible. If there are no further matters, we will adjourn. Thank you.
Thank you.